Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly. And we are continuing with Brent Allen Winters, Declaration of 76, United States Constitution, a common lawyer comments clause by clause. And you'll see at the top the link, commonlawyer.com, and you can be able to purchase the book and study materials as well. All right, let's go ahead and we're going to go through the questions first from last week's reading, pages 141 to 149. Here's the link for that. We'll go ahead and go through these questions. And we have, I don't want it to go that way. Pardon, we make it this so we can see both sides here. Alright, let's see. Hopefully that's a pretty decent view, and I will minimize this over here so that we can be able to get both in the screen. Let's see how that looks. Okay, beautiful. All right. So we have section 2, clause 2. All right, and we are over here. All right. Section 2, clause 2. Okay. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. All right, number 24. In all other cases, let's see, it continues on here. In all other cases, the Supreme Court has appellate jurisdiction, meaning that the cases are tried first. All right, so it should be in here, tried first in a lower court. Here we go, in a lower court, and may come up to the Supreme Court for review unless Congress has carved out an exception denying the general rule allowing appeal. All right, 25. Because the Supreme Court is a co-equal power with Congress, both being direct creatures of the Constitution, Congress has no right to take away or change the Supreme Court's original jurisdiction. Number 26, section 2, clause 3. The trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Number 27. This clause demands that the trial of all crimes shall be by jury, the feature around which our common law tradition turns and holds our freedoms in balanced orbit. Number 28. Our founders, let's see, our founders said the court intended common law's separation of powers, not only of our courts from the other two branches, but even within each court between judge and jury. All right. Next page, 29. Let's see. Here we go. 29. In sum, the Supreme Court identifies our Sixth Amendment right to trial by jury within the common law right, holding that the jury are a pillar of our common law tradition, distinguishing it from the civil laws, codes of admiralty, canon, and administrative law. Number 30, the jury is the only anchor that can bind government to its constitution. Thomas Jefferson. 31, the verdict of the common law jury, impaneled as a sampling of the parties' neighbors, drawn by lot and sitting as a court of judges, looms above all three branches of government concerning the case the jury must decide. Number 32. All right, number 32, the common law principle of supremacy of the jury over all of government, in particular cases, governs in the federal courts as well as in each of the several states' courts. Number 33, in short, if a guilty verdict appears to a juror to be constitutional, but results in its violation, he must hold out for a verdict of not guilty. 34, where the judge's instruction concerning the law's application requires the juror to violate his conscience, his oath never binds him to follow that instruction. 35, the common law requirement. The common law requirement of 1 dozen petit jurors conforms to Christ's example of assembling the same number called disciples and appointing them to be witnesses of his ministry from the days of John the Baptist until his resurrection and ascension. Number 36, that the disciples understood the necessity of the number 12 is seen in their determination to replace Judas. Number 37. All right. The jury of 12 drawn at random, working as a panel of trial judges over the facts and application of the law, and requiring unanimity, has from earliest known times been the mainstay of judging amongst the continental Teutonic tribes, says Blackstone, even into the 18th century. Number 38, the common law jury gives a steadiness to a country unachievable by any other means. Section 3, Clause 1. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. 40. Thus, treason remains a capital crime among all nations. In fact, if not in law, because one act of treason can betray an entire country into enslavement. 41. As a matter of our Constitution, treason is impossible to prosecute without Congress's identification of an enemy. Of an enemy. And Congress's identification of an enemy is impossible without its formal declaration of war. 42. Centuries of common law litigation have shown that confession is the weakest kind of testimonial evidence. It is also shown, however, that confession in open court is an exception to that rule, which is interesting because back with the beginning of 9/11, we had to have the whole outing of the waterboarding process, things like that, and they've proven that torture doesn't actually give you any more information. Okay, number 43. The common law being adversarial breathes the air of rivalry, holding fast to due process. It demands the dignity of fair play. Okay. 44. An overt act is an unhidden act in the furtherance of a treasonable goal. Number 45. Indeed, our common law punishes criminal acts. Mere thoughts and speech in hate or malice are not crimes before our courts of men. That's why all these people can do all that threatening and trying to incite violence, but not get in trouble for it because it wasn't actually any problems. All right, number 46, Section 3, Clause 2. The Congress shall have power to declare punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attained. But that's also why they wait and hold things out for at least 75 years before they try to let you get that information in. Number 47, the phrase no attainder of treason shall work in corruption of blood means that the family of a traitor will never share his guilt before the law. All right, that was the questions from the previous week, so we'll go ahead now and we'll do the reading for this week, 149 to 156, then we'll run through the study guide questions so you have those. All right, let's get this video pulled up. I thought it was up. Pardon the delay, but that won't take but a moment. Great, 149 to 156. All right, here we go. Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator, Lead Recording Secretary for the Indiana Assembly, and we are continuing with Brent Allen Winters' Declaration of 76 to United States Constitution, a common lawyer comments, clause by clause. We'll go ahead and get this going. We are on Article 4. The framers got much of the language for Article 4 from the old Articles of Confederation, by which the general government operated until it began to operate under our Constitution in 1787. Section 1, Clause 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Comment. This full faith and credit clause follows the common law rule. For example, American courts, both state and federal, honor official legislation, court rulings, and records of foreign countries, unless these are shown to be unlawful or unreliable for lack of due process. This clause further requires each state to honor each of its sister states' official laws, court rulings, and records, unless shown to be unlawful or unreliable. To be sure, each state must honor marriages its sister states have declared valid in trusts settled in its sister states. It is beyond debate, however, that neither the farmers nor any other colonial ever had homosexual marriages in their contemplation while drafting and approving this clause. Moreover, their common law tradition holds such false marriages unlawful. Therefore, this clause never requires any state to recognize homosexual marriages, and reasonably so. The laws of nature's God have never recognized sodomite marriages. In sum, our Constitution bars any state or state official under oath to support our Constitution, i.e. protect it from domestic threat, from honoring any unconstitutional or otherwise unlawful decree or act of any sister state. Section 2, Clause 1. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Comment. This privileges and immunities clause requires that any citizen from one state who travels to another state be entitled to all the privileges and immunities that automatically go to citizens of the state to which he has traveled. Some privileges, however, such as the right to vote, do not automatically attach to visitors, but require a period of residence, the will to register to vote, and perhaps other qualifications. The word citizen in this clause does not include government-created fake persons such as corporations. Clause 2, Section 2. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority from the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Comment. Under this extradition clause, if a person is charged with treason, felony, or other crime in one state and flees to another state, the governor, the executive authority of the state from which he fled, can demand that governor of the state to which he has fled to hand him over. Because this clause never mentions misdemeanors, some states refuse to hand over fugitives a sister state has charged with only a misdemeanor. Common law's due process entitles the fugitive accused of a felony to an extradition hearing to determine the lawfulness of the sister state's accusation and the likeliness of him getting a fair trial in the state demanding his return. Sometimes a governor or court will refuse to extradite because the crime charged was done many years before and the evidence has grown stale, precluding any fair trial on reliable evidence in the accusing state, or because the governor or court believes other reasons would prevent the accused from getting a fair trial in another state. Each state must judge for itself. Law against treason is a badge of sovereignty. by the extradition clause acknowledging the right of any state to bring charges of treason, our Constitution affirms the sovereignty of each separate state, thereby limiting the general government. Bottom line, the sovereignty of the general government ends with the list of powers the Constitution delegates to it and at each state's boundaries. On the other hand, the sovereignty of each state covers all within its boundaries federal property with any state excepted. Section 2, Clause 3. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Comment. Amendment 13 supersedes this clause. A person held to service or labor was a slave or an indentured servant, a person having bound himself by contract to serve another for a fixed number of years. Amendment 13 bars any law or court in the United States from recognizing anyone's binding of oneself in slavery to another. Consequently, the foregoing clause no longer has any force. Section 3, Clause 1. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the jurisdiction of two or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as the Congress. Comment. This clause bars forming any new state by dividing or joining existing states or parts of them, unless the legislatures of the states concerned and Congress's consent. Congress relied on this clause during the years 1861 to 1865. The state of Virginia joined the Southern Confederacy, but people in the northwestern counties of the state chose to stay with the Union and split from Virginia. Congress, calling this clause into play, accepted these western adjoining counties into statehood, calling them West Virginia. But without Virginia's consent, Virginia said Congress, by her secession from the Union, forfeited her the right to withhold consent to the forming of the separate state of West Virginia. Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Comment. The word needful limits Congress's exclusive power over property belonging to the United States. This clause also provides a rule of interpretation for the entire Constitution, barring any construing of its terms in a way that will prejudice any claims of the United States or of any particular state. Since the earliest days of our Constitution, Congress has exercised this power over United States property to its full reach, Congress alone deciding whether, to whom, when, and under what terms it will sell, give away, or otherwise dispose of United States land and chattels. The courts and president have no right to interfere. Congress has given land to railroads and aircraft to Christian missions. See this handbook, U.S. Declaration of 76, Section 9, and comment. Because such donations make no law, these do not violate Amendment 1. Section 4, Clause 1, the United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Comment. Do not try to wring more from this Republican form clause than it holds. It requires the United States shall that the general government ensure each state has a Republican form of government. Note well, it is the form that the general government is to ensure and no more. Federal meddling with the inner workings of the state government is off limits. In a Republican form of government, the people elect the representatives to a legislature for purposes of fair taxation and to declare, if necessary, war. However, our Constitution's chief purpose for ensuring to each state a Republican form of government is to ensure the staying power of the general government of Washington, D.C. by first ensuring that each state seats a state legislature so that the most numerous branch of each state legislature can choose senators to send to the U.S. Congress, and second, ensuring that each of the several states sends representatives and senators to the U.S. Congress. In addition, the following 4 observations are noteworthy. First, the Supreme Court says Congress, not our courts, must decide whether a state government is Republican in form. Congress holds that by seating a state's senators and representatives, it recognizes that the people of the state have duly elected their senators and congressmen, and thus, that state's government has a Republican form. Second, this clause requires the general government to protect each state against invasion. This power running with each state's power to protect itself by calling out to muster its militia. Third, a state's legislature can request help from the general government to put down riots or other internal violence. A state's governor, however, rightfully makes such request only if the violence is keeping the legislature from meeting. This clause, by requiring the president to get a state's legislative consent before using national force against domestic violence within that state, limits his power. Using this constitutional principle, even county sheriffs have required notice before allowing federal action in their counties. During the Pullman strike of 1894, President Cleveland sent national troops over Governor Algen's objection into Illinois, saying the strike threatened future movement of the U.S. mail. The troops killed 13 people. In 1957, President Eisenhower put the Arkansas National Guard under his command and removed it from command of Governor Faubus. Outside our Constitution, the phrase Republican government is used in 2 ways, the common law sense and the civil law sense. The common law and constitutional sense refers only to that form of government that elects legislative representatives that are independent from the executive and judicial offices. By contrast, the civil law sense refers to unlimited power of the majority, such as the Greeks' republicanism. See Brent Allen Winter's Excellence of the Common Law, Application 9, discussing 17th century England's view of republicanism. The Latin term republic joins res, a matter of, and publica, the public or the people, thus a matter of the people. Indirect majority will, through power, indirect majority will, through power elections, through popular elections of representatives, distinguished from democracy, the people's business by direct popular vote. Montesquieu, for example, held the ancient Greeks' civil law sense of republicanism used the words democracy and republic interchangeably, advocated common ownership of property as in the Republic of Plato, and praised Lycurgus, the legislature of Sparta, for removing reward for ambition, giving natural affection no outlet, because a man was neither son, husband, nor father. The state, said Montesquieu, instead of citizens, establishes commerce. Our Constitution recognizes the fundamental superiority of the common law tradition over Greek republicanism because provides greater stability for a country through its stressing of relationships and the dignity of individual freedom, both of which Greek democratic republics, being of the civil law kind, still reject. In 1954, even Congress, seeing that the word republic in the American pledge to our flag gave tacit approval to the civil law's communist republics, added the phrase under God after the words the republic for which it stands. The colonials, contrary to Greco-Roman republicanism, held fast to the common law principles that Stephen Langton wrote into Magna Carta 1215, and experience had tempered. Hence, our American tradition of law and government is not a never-before-tried idea. Our Constitution intends republicanism only in the sense that the people send representatives to form a legislative body, foremost to ride herd on governors and presidents. Since such indirect legislative representation is through a majority, Fortescue called it the only political feature of common law government, distinguishing it from civil law government. For example, civil law governments of the Greco-Roman republics, so-called, use no representatives to limit taxation. Simply put, our common law government neither descended from the Greeks nor did our founders model it on any Greek theory of republicanism. To be sure, they cited the Greco-Roman styled republics not for examples follow, but to avoid. In fact, says the Supreme Court, the framers breathed the air of the common law. The framers of our Constitution were born and brought up in the atmosphere of the common law, and thought and spoke its vocabulary. When they came to put their conclusions of fundamental law in a compact draft, they expressed themselves in terms of the common law, confident that they could be shortly and easily understood. Consequently, the language of the Constitution, says Chief Justice Taft, cannot be interpreted safely except by reference to the common law. The founders, however, confronting civil law doctrines then afoot in Europe, sometimes referred to our form of government as a republic, using this term because of its popularity during England's struggle with the crown over a century earlier. The colonies' determination to keep their English common law and government, however, embroiled them in a life and death struggle with England, the mother country. Consequently, many of them were down on anything labeled English. In fact, the phrase English common law aroused misplaced disgust among the colonials against the common law, the very ideal they were fighting to keep. A few decades later, in early 19th century America, resentment against all things English, especially the common law, even fostered an emotional charged and powerful faction out to replace the common law with civil law. To sum up, due to the colonials' growing distaste of all things English, the word republic became preferred to English common law, or even common law. In our Constitution, the word republic does not denote a government's inner workings, but that it uses representatives. Bottom line, courts hold that Congress, by seating the senators and representatives, any state provides any state sends provides conclusive evidence of that state's Republican form of government, and thus bars the general government's intrusion under the Republican form clause. See this handbook, U.S. Declaration of 76, sections 825 to 29, and comments. All right, and that was Brent Allen Winters. Moving forward again in his Declaration of 76, United States Constitution, common lawyer comments, clause by clause. All right, so we'll go ahead then and do the study guide questions that are for that next week's reading. Let me make this a little bit bigger so we can, oh, too big. Let's see how that looks in the, we'll make it a little bit bigger. Hopefully it doesn't. Let's see how that, there we go. All right. So, Article 4, Section 1, Clause 1, full blank and blank shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Number 2. For example, American courts, both state and federal, honor official blank, court blank, and blank of federal countries, unless these are shown to be unlawful or unreliable for lack of due process. Number 3. To be sure, each state must honor blank. Its sister states have declared valid and blank settled in its sister states. Number 4. Section 2, Clause 1. The citizens of each state shall be entitled to all blank and blank of citizens in the several states. Number 5. Some privileges, however, such as the right to vote, do not automatically attach to blank, but require a period of blank, the will to register to vote, and perhaps other qualifications. Number 6. Section 2, Clause 2. A person charged in any state with treason, felony, or other crime, who shall blank from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be blank up to be removed to the state having jurisdiction of the crime. Number 7. Because this clause never mentions blank, some states blank to hand over fugitives. A sister state is charged with only a misdemeanor. Number 8. Each blank must blank for itself. Number 9. By the extradition clause acknowledging the right of any state to bring charges of treason, our Constitution blank the blank of each separate state, thereby limiting the blank government. Number 10, Section 3, Clause 1. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the blank of any other state, nor any state be formed by the junction of blank or more blank or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. Number 11. Congress relied on this clause during the years 1861 to 1865. The state of Virginia joined the southern blank, but people in the northwestern counties of that state chose to stay with the Union and blank from Virginia. Number 12. Section 3, Clause 2. The Congress shall have power to blank of and make all needful rules and regulations respecting the blank or other property belonging to the United States, and nothing in this Constitution shall be construed as to prejudice any claims of the United States or of any particular state. Number 13. The word blank limits Congress's exclusive power over blank belonging to the United States. 14. Since the earliest days of our Constitution, Congress has exercised this power over United States blank To its full reach, Congress blank decided whether to whom, when, and under what terms it will sell, give away, or otherwise dispose of the United States land and chattels. Number 15, Section 4, Clause 1. The United States shall blank to every state in this union a blank form of government and shall protect each of them against invasion. And on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. Number 16, in a Republican form of government, the people blank representatives to a legislature for blank for fair taxation and to declare, if necessary, war. Number 17, second, this clause requires the general government to protect each state against blank. This power running with each state's power to protect itself by calling out to muster its blank. Number 18. The common law and constitutional sense refers only to that form of government that elects blank representatives that are blank from the executive and judicial offices. Number 19. In 1954, even blank, seeing that the word republic in the American pledge to our flag gave blank approval to the civil laws communist republics, added the phrase under God after the words the republic for which it stands. Number 20, our Constitution intends republicanism only in the sense that the blank send representatives to form a legislative body, foremost to blank herd on governors and presidents. Number 21, to be sure, they cited the blank styled republics, not for examples follow, but to blank. 22, when they came to put their conclusions of fundamental law in a compact draft, they expressed themselves in terms of the common law blank that they could be shortly and blank understood. Number 23, consequently, the blank of the Constitution, says Chief Justice Taft, blank, be interpreted safely except by reference to the common law. Number 24, a few decades later, in early 19th century America, blank, against all things blank, especially the common law, even fostered an emotional charged and powerful faction out to replace the common law with civil law. Bottom line, courts hold that Congress, by ceding the blank and blank any state sends, provides conclusive evidence that the state's Republican form of government and thus blank the general government's intrusion under the Republican form clause. All right, that's all the questions for this week's study guide, and so you'll see the link to the YouTube link for where the audio is of the reading, so you can go through the study guide questions. First and third Mondays of the month, our General Assembly and Militia Assembly meet, and the second and fourth Monday, the General Assembly as well as Militia Assembly meet again. This is because the Militia Assembly is connected to all parts of the four pillars, and one of the four pillars being the Militia Assembly itself. All right, and we are supporting the neighboring Kentucky Assembly, supporting them with state coordinator support as they are supporting us with Marshal at Arms support. And we are supporting PKTF, Peacekeeper Task Force, the news site, to keep information across the country. If you know of other platforms, send that info. We're live on all the channels except for Locals, but the videos do go up there. Locals, Odyssey, and Rumble, of course, YouTube. All right, and I need to add, YouTube link is here. All right, so I want to thank you all, and I will see you on the next call. Peace and love.